Hello everyone, welcome to Court with Krissy. What would you do if your Vegas quickie wedding turned into a delayed and decelerated divorce? Maybe start drinking too much? I hope you like it. Court with Krissy is now in session.
All right, good morning, everybody. Ms. Spafford, are we all set on the recording? Yep, okay. Let's go on the record then and file 23-36710-DO. It's Gauthier v. Is it Hannel Gauthier, ma'am?
It's just Gauthier.
Just Gauthier? Okay, Gauthier v. Gauthier. We do have the plaintiff here appearing via Zoom with his attorney, Mr. Hunt. Mr. Hunt, can you see and hear me okay?
Yes, I can, Your Honor.
Okay, and I did just confirm with the defendant that her proper last name is Gauthier, which we've now changed on her screen. We're set for a couple of matters this morning. There is a settlement conference scheduled to begin at 9 o'clock. There also is a motion for sanctions that was filed by Mr. Hunt that covers a couple of topics that we'll go through. There's also a show cause for the defendant. There was a settlement conference originally set in December, I think it was the 16th, 26th perhaps, I'm not sure which, at which the defendant did not appear. Mr. Hunt's motion for sanctions concerns that, as well as the show cause hearing, the first one for which she failed to appear on, I think it was January 9th of this year. And so, Ms. Gauthier, I guess let me start with why did you fail to appear for the first settlement conference in this case?
I never got the mail.
Okay.
That's all I didn't know.
Okay, and did you give the court your proper mailing address? Because there was some indication that the one we had perhaps was your mother's.
I don't want Brad to know where I live. So yes, that is my mother's address.
Okay, and were you regularly receiving mail at that address?
Yes.
Okay. And if we would have sent it to that address, do you know why you would not have gotten it?
No, I don't. I don't know if she lost it, if the mailman lost it. I have no idea.
Okay. Let's go to the show cause that was in, well, earlier this month. What was the reason that you failed to appear for that?
I didn't even know I was supposed to be there.
Okay.
Otherwise, I would love to be divorced yesterday.
Okay. Mr. Hunt, I've had a chance to review the motion for sanctions. Any additional argument for you on that one?
Well, Your Honor, just so you're aware, I've tried to communicate with her in the past. I've sent letters to her mother's address, never gotten a response. I've texted her letters that I've not gotten a response to. But she was aware afterwards that I believe I wrote a letter to her after the last settlement conference indicating that she missed it. And I don't know why she hasn't responded to anything, but unfortunately, because of her failure to appear, I had to prepare for the settlement conference last time. We waited for her to appear for a period of time, and then I had to appear at the show cause conference as well. So I would ask for the attorney fees that I've mentioned in my motion and for my client to be reimbursed for his time for a half a day of work that he missed on the date of the settlement conference.
Okay. So, Ms. Gauthier, what's been requested or what's been filed is what's called a motion for sanctions. And due to your failure to appear for the previous two hearings, Mr. Hunt is asking the court to grant his motion, which would authorize his attorney fees for having to prepare for really the settlement conference hearing. I don't think that he requested anything specific to the show cause, as well as the plaintiff missing a half a day of work for the original settlement conference date. So do you have any argument you'd like to make on your behalf?
That's ridiculous.
Okay. Any additional argument that you'd like to make beyond that?
No.
Okay. Well, we are set for a settlement conference this morning. The way the court understands it is that the defendant supplied her mother's address because she did not want the plaintiff to know where she is residing. Certainly that it may be an appropriate precaution for somebody to take in terms of publicly broadcasting their address. But in terms of the court having the proper address or a way to contact somebody, it's each party's responsibility to provide us with a means so that they can properly get notices for hearings and any other mail or correspondence that the court has to provide as well as a mailing address for the other party so that they can be properly served with whatever documentation is appropriate or whichever documentation needs to be provided. In this case, there was a previous settlement conference in December of 2023. The defendant failed to appear for that. Notice would have been provided to her via mail because I assume she is not linked to the electronic website. Based on that, it would have been provided to the address that she provided us. It's her responsibility to monitor that, not anybody else's nor her mother's. And she also missed the show cause earlier this month. And so I will grant the motion for sanctions. Mr. Hunt, if you could please prepare the order listing the monetary amounts that you did list. I'll go ahead and sign that. And then both of you can just, actually, I think you have to go over to the other Zoom channel for the settlement conference, which is scheduled to begin in 10 minutes. So Ms. Gauthier, do you have that Zoom link as well?
Yes.
Okay. So both of you can sign into that in 10 minutes. And Ms. Quinn will be on there to guide you through the settlement conference. Thank you. We're all set.
Thank you, Your Honor.
Okay. Well, I suppose we can go ahead and get started. And if history holds, if she's going to show up, she'll do it right after I get started. So we can go on the record then and file 23-36710-DO. It's Gauthier v. Hannel Gauthier. Mr. Gauthier is here this morning with his attorney, Mr. Hunt. The defendant has not appeared. We're here for a show cause, essentially for a failure to file the judgment. And Mr. Hunt, I'm guessing that based on past experiences in this case, that's not on your end. Have you had any contact with the defendant in this case?
No, I have not, Your Honor. In fact, we went to mediation. I think I explained this to you before. We had an agreement based on the mediation agreement. I prepared a proposed consent judgment of divorce, had it approved by my client, sent it to her for her signature. I had also sent her a quitclaim deed to extinguish her interest in the real estate. I have not heard from her after we appeared at the final hearing the last time, and she didn't appear and hadn't signed or responded to anything. I sent her another letter that indicated that there was a show cause, sent her a copy of the order. I texted it to her and sent it to her at the address we had. I've not heard from her at all. I have no idea why she hasn't approved this. It's to her benefit. She actually gets money paid conditioned upon a certain time from the entry of the judgment. So I have no idea why she hasn't appeared.
I would love to be divorced yesterday.
Okay. And so the proposed judgment that you've prepared, that's based on the agreements that you all reached at mediation. Is that correct?
Yes, it is, Your Honor.
Okay. Then I think what we'll do is this. I don't want to delay this process anymore. And her lack of participation is the reason that it's been held up really at every step of the way. So if you could please file your judgment as a default judgment of divorce.
Okay.
With the proper notice. And then obviously she'll have to be provided a copy of that. But I think certainly if the terms of that document are what was agreed to by both parties at the mediation, then it's perfectly appropriate for the court to consider it in that capacity, I think. Plus, given that she's already agreed to those terms, plus I don't want to hold it against your client, the fact that we can't get her here and she fails to appear and won't provide us any of the contact information. So we'll do it that way. Obviously, there'll be a 7-day hold on it once the court does receive it. So, Mr. Gauthier, there are time restrictions on that type of judgment, but certainly Mr. Hunt will provide her with the requisite copies of it. She can object if she wishes, but given that she agreed to the terms of it, I don't see that happening. Plus, this way, 7 days after it's received by the court, I can execute it if there's no objection filed. And then that way it'll be done and everybody can move on. So any objection to that plan, Mr. Hunt?
No, Your Honor. I was just wondering, do you want me to prepare an order of default for her failure to appear and then provide the default judgment? So it's...
Oh, that may be the cleaner way to do it, even though she did appear for mediation. Yeah, if you could do it that route, that's probably best.
Yeah, and the other thing is obviously, my client is, you had ordered her to pay attorney fees before for her failure to appear when she was supposed to appear. That was considered and deducted from what she was receiving as a part of this judgment. I would ask for another hour of my time another $250 be ordered to be paid by her for not appearing and putting us through this process?
Well, she did fail to appear today. What I would indicate is because you're going to have to file the default and the default judgment, whatever time I would order as a result of her failure to appear today, whatever time you spend doing that process, given that it should have been wrapped up through a consent judgment of divorce, that may also be included.
Okay. Thank you, Your Honor.
Okay, thank you. Mr. Hunt, good morning.
Morning, Your Honor.
Do we expect Ms. Hannell to appear this morning?
I really am not sure. She knows about it. I have not heard from her since the time of the mediation.
Okay, were you all able to resolve everything?
We resolved the case. I've sent a judgment. My client has approved it. I sent one to her mother's house, which is the address I was instructed to send it to.
Yep.
And I have not heard from her. And last week, I think it was Thursday or Friday, I left a message at her mother's house because I couldn't get through to her mother either. So we don't have an approved judgment. I would ask if we could at least put the proofs on and await her signature on the proposed judgment.
Okay. At the did you guys resolve everything there?
Yes. Yes.
Okay. We'll give her a couple of minutes to appear, and if she doesn't, then we'll take some testimony from your client and preserve that.
Okay. Thank you.
Yep. Okay. Well, that's enough because otherwise we're going to impact the other files that I have. Let's go on the record and file 23-36710-DO. It's Gauthier v. Hannell Gauthier. We do have the plaintiff appearing with Mr. Hunt on his behalf. The defendant is not here. Prior to going on the record, I did ask Mr. Hunt if he knew whether she'd appear, and he did not. As the record has been clear the entire time for this case, there's been difficulty in getting her to appear for things. But they did have a mediation, and apparently everything was resolved at that. Is that correct, Mr. Hunt?
That's correct, Your Honor. I can put that on the record if you would like. It was through CRS, and
Okay.
The CRS may have even sent you a copy of the mediation agreement.
Generally, they do. Yep.
But everything.
My understanding is too that judgment of divorce has been prepared and signed by your client. You're just waiting on its return from the defendant. Is that correct?
That's correct. Okay.
And you requested to take some testimony from your client, and we preserve that, which I do think is appropriate, even though the defendant's not here. If it's resolved through a consent situation, I don't have any issue with that. So, Mr. Gauthier, if you would please raise your right hand, sir. Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. If you could start out, please, by just telling us your full name and then spelling your last name for the record. Thank you. Mr. Hunt, go right ahead.
Thank you, Your Honor. You're the plaintiff in this matter, is that correct?
Yes.
And according to the complaint, you were married to the defendant on May 27th of 2018, and it was actually in Las Vegas, Nevada?
Yes, that's correct.
And her maiden name was Jacqueline Marie, is it Hannell?
Hannell, yes.
And according to the complaint, you were a resident of the state of Michigan for more than 6 months immediately preceding the filing of the complaint. Is that correct?
Yes, that's correct.
And you were a resident of Grand Traverse County for more than 10 days immediately of filing the complaint?
Yes, that's correct.
And the two of you separated in approximately October of 2022.
Yes, yep.
And you've been living separate and apart since that time.
Yes, that's correct.
And there was certain, well, I mean, there were no children born of this marriage, correct?
No, no. there
And
isn't.
to the best of your knowledge, she is not presently pregnant.
Yes, that's correct.
And there was certain property that was acquired during the course of the marriage.
Yes,
And that's been divided in a judgment of divorce pursuant to the mediation.
yes,
And do you believe that that's a fair and equitable division of the marital property?
yes, I do.
And you're asking that to be incorporated into the terms of the judgment.
Yes, I do.
And you understand that a judgment of divorce is final and binding as it relates to property and can't be changed in the future absent fraud or misrepresentation.
Yes, I do.
And has there been a breakdown of the marriage relationship?
Yes,
Is there any possibility that the marriage can be preserved?
no,
I'm not sure I have any other questions at this point, Your Honor.
Okay, the court does not have any additional questions. We'll find that the statutory grounds are met based on the testimony from the plaintiff, and the court will preserve that testimony. Mr. Hunt, I think what I'll do is simply indicate that the judgment needs to be filed within 14 days. If you're unable to do so because of lack of participation on the defendant's part, I'm sure after the 14 days, you'll get the snail mail hate letter from the court indicating you were supposed to file it. And so if you could just notify us at that time that we're still having issues, what we'll do is set it for a show cause, and then we'll try to resolve it that way. Okay.
Yeah, and I'll write her a letter about today's hearing as well.
Okay. Thank you very much.
All right. Thank you, Your Honor.
Good morning, Mr. Hunt.
Good morning, Your Honor.
Do you have Mr. Gauthier with you?
Yes, he's right next to me.
Good morning. And you are Bradley Gauthier.
Yes, I am.
We are on the record in case number 24-1138FD, and you are appearing with your attorney, Mr. Hunt, for arraignment purposes this morning.
Yes,
Hunt,
ma'am.
did you have opportunity to review the allegations on the complaint, the nature of the offense, and the possible maximum penalties with Mr. Gauthier?
Yes, I have, and I believe he understands the charges against him and the potential penalties. At this time, we would waive the reading of the complaint.
So there was an amended complaint. I just want to make sure that you were aware of all of the charges.
Yes, I believe that included habitual charges,
Yes.
and there were
Yep. And the
a couple of misdemeanors. But
resist and obstruct. Yep.
that's-
Okay.
yes, thank you.
Thank you. Mr. Gauthier, I'm going to remind you, sir, that you have the right to remain silent. Anything that you say, orally or in writing, can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. And you have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, the preliminary examination will be scheduled for February 29th. It will be at 11 a.m. with Judge Stepka. Also, on February 23rd, you would have a probable cause conference. So, Mr. Hunt, bond has been set in this case. Do you have any questions or concerns regarding the bond?
I don't believe so, Your Honor. I would indicate for the record that in the event that there's an issue about the preliminary examination based on evidence or discussions with the prosecutor, my client would waive the 21-day rule. He understands he has a right to have the preliminary examination within 21 days, and by waiving it, it may be outside of that time frame.
Thank you. So, Mr. Gauthier, what Mr. Hunt has just indicated is that you have the right to get this case moving forward as quickly as possible. And within 21 days from today's date, that you would have a preliminary examination. However, there may be issues with regard to evidence or discovery information that Mr. Hunt would need to properly represent you. And so what he's saying is that it's your wish to waive that right to the 21-day rule, and that if it's necessary, that the preliminary examination might be held at a later date. So is that your wish?
Yes, ma'am.
All right, thank you.
You're
So
welcome.
for right now, we're going to leave it as it is. Is that right, Mr. Hunt? And
Yeah.
if there are any issues,
That's correct, Your Honor.
okay. So we'll leave it as it is. The bond will be continued. Mr. Gauthier, I want to verify contact information with you, please. And you are currently working with Community Corrections Pretrial Services, is that right?
Yes, that's good.
Okay, very good. Thank you, gentlemen, for your appearance this morning, and you're free to leave the meeting.
Thank you, Your Honor. Have a good day.
You as well, sir.